Hey everyone, Chase Elleby and Joel Williams with Williams Elleby here with you today with video number 36 in our series of 52 weeks of personal injury. And today we're going to be talking to you about expert witnesses in your personal injury case. So there are a handful of experts that you could have for any particular case. Things like doctors, accident reconstructionists, economists. I mean, the list can go on and on and on. So Joel, when do you need an expert and who can actually be an expert?
So, not all cases require an expert, obviously.
Right.
Most do in some shape, form, or fashion, though. But we look at experts in the personal injury lawsuit space, and not even personal injury, sometimes it's breach of contract and things like that. Because honestly, man, sometimes I feel like you can be an expert on the correct way to chew bubble gum.
Right.
Like, I mean, there's experts for everything. But typically in a personal injury case, because that's what we're talking about today, you're going to have medical professionals that can testify as to causation of of injuries, of future prognosis, all that kind of stuff. You may have economists who are going to testify regarding lost wages or lost profits and that kind of stuff. You may have, if it's a car wreck, you may have accident reconstructionists. They can come in and talk about how the wreck occurred, speeds, coefficient of frictions, all that kind of stuff. You may have biomechanics if it's a really complicated wreck that'll talk about how forces are exerted on the human body and all of that kind of stuff. And I know there are others, but that's what we typically run into the most. The interesting thing about experts is that they are allowed to offer opinions in scenarios where that subject matter is, according to the law, beyond the knowledge of the average layperson.
Right, it has to help the jury, right? You can't just have an expert if they're not really going to do anything to assist and aid the jury in determining whatever the issues are that they're supposed to decide.
Yeah, like you don't need an expert to come in and tell the jury, when you get to a stop sign, you're supposed to stop.
Right.
Right, like you know that, everybody knows this. If you drive a car, you know to stop at a stop sign. However, you may need an expert if you're talking about situations where one party says, well, I was completely within my lane of travel, and the other party says, no, I was in my lane of travel, and you came into my lane. Well, you may need an expert accident reconstructionist to go to the scene, take measurements of the scene itself from roadway defects and marks, or to go look at the vehicles and take measurements according to damage, so that they can then try to deduce from that evidence who's correct, right? And you may have a plaintiff's expert and a defense expert that disagree.
Right.
You usually will.
Right, have their own opinions about what they think. You know, another good example we see a lot, I'd say most of our cases to some degree come, you know, with the medical expert, right?
Oh, yeah.
It's always about the doctors. As the plaintiffs, we usually get the treating physicians to testify in their expert opinion whether or not the incident, whether it's a car wreck, slip and fall, whatever it is, cause the injuries, and whether or not those injuries are permanent or not permanent, and whether it's, you know, obviously related, right? And defense attorneys will sometimes hire an expert, a medical expert, to come in and say, well, no, if you were injured, this was something that pre-existed the wreck, so we're not responsible for it. So it usually becomes a battle of the experts.
Yep. Anytime you're in a case where experts are involved, I think it's important to, at least for the attorneys, and hopefully if you're in a case where experts are involved, you're not representing yourself, but for the attorneys to understand the law that controls the admissibility of the expert's opinion. Start by reading Daubert versus Merrill Dow Pharmaceuticals, Kumho Tire, Joyner. You probably read it in law school. If you're not a lawyer, you got no idea what I'm talking about, but those are U.S. Supreme Court cases that set forth the criteria that courts are to consider when they are deciding whether to admit an expert's testimony. Generally, without going into all the nerdy stuff dealing with that, the expert has to be qualified. They have to have sound methodology when it comes to doing the investigation and reaching their conclusions. They have to come to their conclusions in a way that fits the methodologies and the facts of the case. And the reason for this is, I believe, if you were to ask the justices who decided that case, they understand that experts are usually paid a lot of money.
Right.
And money talks. And if you pay somebody enough money, if they don't have a accurate moral compass, they'll say whatever the hell you want them to say, right? So there are these safeguards in place now to make sure that these experts who are highly compensated, and I'm not bashing experts for being highly compensated, because they should be paid.
Right.
They have areas of expertise and they work hard to get there. But it's to make sure that the testimony that comes in is at least reliable, right? And a jury can completely disregard an expert's testimony, or they can accept it as true. There can be two experts that look at the same evidence and come to different conclusions, and there usually are. But there are at least safeguards in place to make sure that that testimony and the methodologies that the expert uses are sound and aren't just completely out there in left field.
Oh, right, and it gives the judges, sort of the rule book to decide whether or not to let him in or not. Because judges are always the gatekeeper of any evidence, right? So Daubert is basically the rules for the judges to decide whether or not this expert is in fact an expert. Their methodologies are, peer reviewed is obviously, one thing, and whether or not they can come in and they can testify to the jury. So we've talked a lot about experts, and how they can be helpful, but how can experts hurt?
Yeah, so that's honestly the whole purpose of them, is to hurt your opponent's case. Right. You hire experts for specific reasons, either to bolster your case or discredit the other side's case, and preferably both. And so it's important in my mind to find experts that are credible, so that when they offer testimony that may be harmful to your opponent's case, that it's believable. Now, if you don't hire an expert that is credible and has a good reputation, you can hurt your own case.
Oh, absolutely.
Because they're not going to be able to withstand vigorous cross-examination from your opponent. They may have too much baggage. Maybe they've been excluded by courts before. Maybe they have
shaky methods.
Yeah, shaky methods. Maybe they charge $5,000 an hour for their testimony, and everybody knows that's absurd, regardless of what field you're in. So you have to be careful, because they can hurt your case if they can't stand up to cross-examination, or if they're not credible. And if the other side hires a really good expert,
yeah, it's going to hurt your case.
Might be in trouble.
Right.
So you got to make sure that whatever expert you hire is capable of holding their own.
Yeah, exactly. And it's sort of the double-edged sword. You want an expert who knows what they're doing, which is obviously is going to require an expert that's very experienced, possibly an expert that's expensive. So, if it's a defense expert who always testifies for the defense, one of the things we're always going to cross them on is, well, you only testify for the defense, right? You do 99% of your cases for the defense. And on the flip side, there's experts that primarily testify for the plaintiff. So that can go against the credibility of that expert witness. So
yep. So do your background research and make sure that your expert that you hire is credible and not just a hired gun. Yeah. So hired guns usually don't get you too far in litigation.
Yeah,
so,
absolutely.
Really, that's about it for me as far as experts go.
Yeah, no, I think we covered.
Anything else to add?
No, I think we covered a lot. Like I said, it can be a pretty sticky area of the law, especially when it comes down to Daubert and filing those motions and things like that. But it's, I think, a very good expert in a good case can be critical.
Yeah.
So
if you want to learn more about it, just hit me up. I've got about a 500-page treatise in my office that you are more than welcome to come flip through.
Right. Yeah, check it out. Check it out at the Joel Williams Library.
That's right. We're not going over all that today. So.
All right. Well, we appreciate y'all watching this video. Please hit the like button, subscribe. If you have any comments, please put them in the comment section. And if you think of any questions or anything like that, just let us know. And of course, we will see you next week with our video series, week number 37. So, see y'all later.